Hey, good afternoon, everybody. It's Bo Howell, FinTech Law here in Hilton Head, South Carolina. The weather was much nicer yesterday, I can promise you that. It's definitely foggy, as you can see behind me. The ocean's just back there, and you can probably can't even make it out. Whereas yesterday, we were watching dolphins swim by in pods. But it's day one of the ABA's Derivatives and Futures Law Committee winter meeting. And as you can expect, one of the reasons why I'm here, one of the reasons why a lot of people are here, is there's a lot going on about crypto. And that was a topic, a minor topic du jour today. You could tell there was a concerted effort to not spend the entire conference talking about crypto. So they talked about a number of other subjects, but I wanted to hit on a few of the important points that came out of the enforcement discussion, which was the majority of today's discussion. So one, we did have a representative of the CFTC here, and that was helpful to hear her position and, somewhat indirectly, probably the CFTC's position on crypto regulation, right? And I've written about the turf war between the CFTC and the SEC. It continues to be ongoing. And that did come up a little bit today. One of the things that was mentioned was how last year, the CFTC spent about 20% of its new cases focused on the crypto and DeFi space, and they brought 18 cases. That's what that 20% represents. Now, you compare that to the SEC, who for a similar time period, I think brought around 50, maybe a little more than 50 cases. So it's a big gap, right? And that's led a lot of people to believe that, well, hey, maybe the CFTC is not as aggressive as the SEC when it comes to kind of anti-fraud enforcement. But the point that was made today, at least by the representative of the CFTC, was that it's not really a matter of aggressiveness. The CFTC has a much smaller staff. Their enforcement division is a lot smaller. And so it's more a matter of resources. And that was actually echoed by another speaker later in the day who noted that the SEC can get a lot of its funding through end user fees and other mechanisms, and isn't as dependent on Congress as the CFTC is for funding. And so I thought that was an interesting point. There was a discussion around how the last time the CFTC's jurisdiction was substantially increased was as a result of the Dodd-Frank Act after the 2008 Great Recession. And that while the CFTC was expected to start regulating a lot more intermediaries and products, particularly around like swaps and derivatives and some of the products that caused the collapse at that time, their budget really didn't keep up with their expanded jurisdiction. So Congress gave them essentially a lot more work to do, didn't give them any money to hire anybody to do it, or at least the money they gave wasn't enough to kind of cover what the commission needed. So I thought that was an interesting point, in fact. And so, I think that's something to think about as we get down the path here, this regulatory turf battle between the SEC and the CFTC. Part of the SEC's approach has been it's got a lot more resources. It's somewhat self-funded, and it can really go after its regulatory agenda, whereas the CFTC is more dependent on Congress for a lot of its resources. And that's probably why it has to play more of the role of the diplomat versus the SEC, who could play more of the role of the enforcer, which was the title of my most recent blog on this matter. So an interesting point, the CFTC is bringing cases. Most of the cases that they're bringing right now deal with basic registration and anti-fraud, which is kind of historically what you see in new markets. The first cases that come out from the regulators focus more on these kind of registration and anti-fraud. And once you clear through that backlog of cases, we expect to see the commission getting more into market manipulation and more complex cases against intermediaries and other individuals, maybe more insider trading cases, things like that. So, we're just scratching the surface here on this point. The CFTC is engaged. They are focused. This is a priority for them. And, maybe if one of these new congressional bills passes, which I think both of the ones that are before the Senate and the House right now do give the CFTC the ability to self-fund a little bit through end user fees. If they get that type of funding mechanism, maybe it will allow the CFTC to kind of close the enforcement gap between the SEC and the CFTC. So an interesting point. I'll continue to bring you more information from the conference. Hopefully the next time I record a video, it'll be a little nicer outside. In the meantime, feel free to check out the content that I'm posting and FinTech Law is posting on LinkedIn. If you have any questions, send them my way. Have a good night.